Thank you, Elizabeth. I'm both an elder law and now at 71, I guess I'm an elder attorney too. So I guess,
Oh, sorry.
and I also do estate planning and estate administration. So that's why I know something about being an executor. I'm intrigued that so many of you are interested in learning about being an executor. That's really kind of interesting to me. I think there's more people here than we usually get, although we get quite a few, but I think there's more today than we usually get. So I'm intrigued as to the interest in wanting to know the duties of being an executor. So to begin, we need to get some terminology set. So the first thing is, what is the definition of an executor? Well, the executor is someone appointed under a will to carry out the directions in the will upon the person's death. So that's what an executor is. If there is no will, the person that gets appointed is called the administrator. Okay, so executor is with the will. If there is no will, if someone needs to be appointed on an estate, they're called an administrator. There's some other terms that are used, but it gets more complicated and it will only confuse you. So I'm not going to get into that. So executors, as I said, in a will, when I draft a will, I ask the client who they want to be the executor, and we put in the name of an executor. And we might oftentimes put in successor executor if the executor is not available to carry out their duties. So that's actually in the will. You have to name somebody. So every time you do a will, that's always the issue. Who's going to be the executor? Who's going to be the successor executor? Oftentimes we have to update wills because the one of the successor executors is not available, or maybe we want a new successor executor. Usually when I'm doing wills for a couple, I'm doing a will for each spouse, and they're naming each other as their executor. So each spouse is naming the other spouse as their executor. But then there's always the issue if that spouse predeceases, so we're going to name a successor executor in the will. Now, just because someone has done so, a will doesn't mean that you actually have to open up an estate and go through all the formalities and things that an executor has to do. Why is that? Well, if you think about it, there's a great number of assets that people hold today that are never going to pass through their will, ever. So what are those assets? Well, one of those assets are retirement accounts. Retirement accounts, IRAs, 401ks, 403bs, Roth accounts, you have designated beneficiaries. And hopefully, if that beneficiary is not around, you've named some contingent beneficiaries. Those accounts normally will not go through the estate. So that's, for a lot of people, a big chunk of change that people have. So it's not going to go through. Similarly, life insurance policies are usually made out to a particular person. So that person, upon the person's death, the life insurance policy is going to go directly to the person. It's not going to go through their will. Thirdly, you may have bank accounts and other things in which you've designated a pay on death provision. That is to say, you're going to say this account gets paid to this person upon my death. That's not going to go through your will. And finally, you may have a lot of accounts that are jointly owned. You may have a lot of accounts that are jointly owned with your spouse or with a child, or your house could be very well jointly owned. Upon one of the joint owners' death, the other person owns the account. So if you think about it, it could be, even though a person has a fair amount of assets, there may not be any reason to open up an estate. You only open up an estate in Virginia, and really any other place, if the only way of getting money from the decedent needs to go through an estate, because that's the only way to do that. So what does it mean to open up an estate in Virginia? Well, so you have a will, and you've named an executor. The person dies, say, in Arlington. Their residence was Arlington. The first issue is, if we know that we have money, that the only way, or assets, the only way to get those assets to the intended beneficiaries is to open up an estate, then the executor will have to make an appointment with the probate clerk in Arlington to have an appointment to open up an estate. They will need to bring the will. They will need to bring the death certificate. They will need to have some idea of how much assets are passing under the estate. And they will need to also bring something called a list of heirs. Okay. So who are the list of heirs? The list of heirs, interestingly enough, are those people who would take under intestate succession. What I mean that if the person had died by will, the list of heirs, or who the people would take under the rules of if they had died without a will. What does that mean? Let's suppose you draft a will and you have 4 children, your spouse is gone, you're leaving your estate to 3 children, but 1 child you've decided not to leave anything. So who are the list of heirs? The list of heirs that you have to bring to the courthouse is all 4 of the children, plus their addresses. Why is that? Because the list of heirs are entitled to a special notice saying the person has died, they've died by a will, and here is where the estate is being probated, Arlington County. So that puts that child on notice who didn't get anything that an estate. Now they may then, they may then, if they then find out they're not going to get anything under the will, then at least that gives them notice if they think that something wrong happened, which is possible. So, but the law requires that you file this list of heirs, and you also have to give them notice. That's actually the first duty of the executor, to make sure that the list of heirs gets noticed. There's a statute on it. So you first go to the probate clerk, you present these documents, and the probate clerk opens up an estate with you of the executor. If the bond has been waived in the will and you are a Virginia resident, the executor, then you don't have to pay what's called a bond. A bond is simply an insurance policy that insures the estate in case the administrator does something wrong or the executor does something wrong. The bond is simply an insurance company. So if there is a requirement of bond, and there is a requirement of bond If you are an out-of-state executor, you still may have to post bond if you're an out-of-state executor. So you can't waive that if you live out of Virginia. So that person will have to post the bond, which is an insurance policy. There are bonding companies, and generally the decedent's estate will pay for the bond. Okay, so now you've been named the executor. You've qualified. The will's been probated. The will's been filed before the courthouse. And you're now the executor, and there's assets that have to actually pass through the estate. Okay? For instance, there might be some bank accounts. There might be brokerage accounts. So forth. There could be retirement accounts that nobody named a beneficiary for. That's possible. So that will all have to go through probate. Because if you have a retirement account and you have no designated beneficiary, it's going to have to go according to the will now, because that's how you've determined where things go. So we don't have in Virginia a probate court. There's no separate probate court. There is one in DC. There's separate probate courts in Maryland. There is nothing like that in Virginia. The final authority for estate administration is the circuit court, which is the trial court where you have jury trials in Virginia. Instead of having a probate court, we have these special people named commissioners of accounts who are appointed by the circuit court in each jurisdiction. So there's a commissioner of accounts in Arlington, in Alexandria, in Fairfax, in Loudoun, in Prince William, and throughout Virginia. There are these separate offices called commissioners of accounts. And their job is to make sure that things occur according to the estate administration procedures in Virginia. So if you have to open up an estate, okay, within a certain period of time, you are required to file before the Commissioner of Accounts an inventory. An inventory. What is an inventory? An inventory is the starting place, the amount of assets that are actually going to have to be run down through the estate based on the value of everything at the person's death. Not before death, but at death. So if a person died with a brokerage account, if they died on, what are we? We are April the 17th. If they died Monday, tax day, April 15th, and they have a brokerage account of $350,000, we have to get a statement of what the amount was on April 15th, $350,000. That's goes into the inventory. Okay, that's the starting place. If a house actually is going to be run through the estate, okay, then we're going to have to get a valuation of the house upon date of death. Okay? Other accounts, anything else, any other bank accounts, we need to show on a form that Virginia has prepared, an inventory form, which says they had this property worth this amount, they had this property worth this amount, this is the property in Virginia. Oh, they might have had some other property in another state. You list that also. Oh, that's not going to get probated in Virginia. So you list all the properties that you have. That's your starting point. Okay. You then, the executor should open up a separate account in which called an estate account with a separate tax ID number that you get from the IRS. It's an estate tax ID. Because the person has died. You're not going to be able to use their Social Security number for income. Now, if there are assets and those assets are earning income, they go under the new estate tax ID. Okay? So that you open up a separate account for those assets. And then you move the assets that were in the person's account. Let's suppose they had an account at Bank of America, and you've decided to open up an estate account at United Bank. You then, as the executor, you prove that you're the executor. You say, I'm the executor, I'm going to close this account. And then you take the money, the BOA writes you a check as the executor, and you take that account and you deposit it in the new account, the estate account under the new tax ID in United Bank. And you do that for everything. Okay? And you pretty much want to run most of your estate through that estate account. Now, you are still going to have to get statements upon the date of death. Let's suppose the person died in April 15th, but you don't open up the estate until, I don't know, June, for whatever reason. You're going to have to get bank statements from BOA for April, May, and part of June, perhaps. Because they're going to want to, the Commissioner of Accounts is going to want to see all the bank statements later on from the date of death. Okay? In fact, when you gather all those bank statements, that's getting ready to prepare something called an accounting. And here's where things get tough, folks. What is an accounting? So an executor, after a period of time, has to file an accounting before the Commissioner of Accounts. So what is an accounting? Based upon what you said in the inventory, every asset that has earned income and any distribution you've made, any, not just distribution, expenses that you've paid, have to be accounted for before the Commissioner of Accounts over a period of time, usually a year, although you can do it earlier. So, and it has to fit to the penny. What goes out has to be accounted for. What comes in has to be accounted for, and it's all got to add up. So the Commissioner of Account is going to want to see bank statements. It's going to want to see checks. Going to want to see what else? Any distributions you made to individuals, receipts that they've received the distribution, all that stuff has to be done, has to be accounted for. That has to occur until the estate is closed. To the day that it's closed, all of this financial information has to be provided to the Commissioner of Accounts. That can be a lot of work, okay? Particularly if there are brokerage accounts and their sales and their gains and losses. All that has to be accounted for before the Commissioner of Accounts. That is a pain. And you often need somebody who is experienced, who knows. I have a paralegal who's experienced and does that. I don't have the time to go through all the financial sheets. Or you can use some accountants who specialize in this kind of work, who understand what the Commissioner of Accounts. That's not true of every accountant. In fact, that's not true of most accountants, but there are a few who are experienced, or other private people who understand what the Commissioner of Accounts is going to require. And if the Commissioner of Accounts is not satisfied, well, you have to satisfy the Commissioner of Accounts. And if you don't, if they don't think that they're getting what they need, they can take you to court. And, then you can go before the judge and explain, why you couldn't get X, Y, and Z, or why this is done. And usually they'll give you more time. But they want, the judges want to know that the Commissioner of Account is satisfied. Now, they'll work with you. They'll tell you what you need and help you a little bit. But they're not going to do the work for you. So that's one of the issues. That's one of the issues about probate. It's providing the information to the Commissioner of Accounts so they're satisfied, because it's only when they say, okay, everything is okay, we'll tell the circuit court that everything is okay, the case is closed, the estate is closed, you got a problem. So that's just something to keep in mind. It's no great pleasure to be an executor. It's work. You can, if you're executor, you get a fee based upon the income comes in and the amount of the estate. You get a fee. However, if you need to hire somebody to do the accountings, and I strongly suggest that people don't know what they're doing, they do that, your fee is reduced by the amount you've paid to this other person to do the accountings. So in that case, your fee could be lowered. On the other hand, if you need an accountant to do tax returns, that doesn't lower. You're not, as an executor, you're not expected to be an accountant. You're not expected to do tax returns. You can, but you can go out and hire an accountant, and their fee is paid as an expense to the estate. So that's an important thing to understand. So you've opened up an estate, you've filed an inventory, you've done your first accounting. You would now like to close the estate. You've paid all the bills, you paid the taxes, you now want to close the estate. And you want to close the estate in a way that protects you, the executor. So you can ask the Commissioner of Accounts to hold a special hearing called a debts and demands hearing. Now, if you know that there are some creditors out there that have to get paid and you have a dispute with them, you can bring them in the debts and demands hearing, and they can make their claim as to why they think they're owed money, and the Commissioner of Accounts will decide. If you say, I don't think they're owed money, the Commissioner of Accounts can make that decision whether the estate owes money or not. However, most of the time, you've paid all the creditors. You say to the Commissioner, I think I've paid all the creditors, but we want to have a debts and demands hearing. So the Commissioner will hold a debts and demands hearing. Nobody shows up. You don't show up. It's in their office. They post it in the newspaper and on the docket in the court, and nothing happens. And they say, okay, uneventful debts and demands. So why would you do that? It's part of the way of protecting you, the executor, from future or claims that you had no idea about. It's one of the ways in which we cut off claims for outstanding creditors of the decedent that you knew nothing about and would have no reason to know about. You then can do a further hearing before the court, which would also, this further hearing, really you go to court and get a final, what's called a show cause hearing. It's a show cause for anybody to show up if they think they either should get a distribution, or if the creditor thinks they owe any money. It's published. and you get an order of distribution. You go to court. I, as the attorney, go to court. The judge calls the case. I bring my order of final distribution. It says there is $20,000 left in the estate, and the $20,000 is going to be paid out this way. It's been approved by the Commissioner of Accounts. The judge signs the order. We then pay everything according to the order of distribution, and then we show to the Commissioner of Account, look at my estate account. There's no money in it. Everything has been paid out. We file a special form that say the taxes have been paid. There's a special form. The executor is responsible for making sure that the decedent taxes are paid and that any estate taxes are paid. So you got to file something with the Commissioner of Accounts to say, I've used the assets in the estate to pay any outstanding taxes, both federal and state. And you then get a nice letter saying, thank you from the commissioner. This matter is closed. It goes, they file something before the court, and after 30 days or so, it's ended. And that's it. There you go. That's the life of an estate in about 20 minutes. Have I left some things out? You bet. I've left some things out. But, there are all kinds of different complications that occur. What could occur? What are some other complications? Well, one complication I have is a lawyer wrote a will that was ambiguous about whether the 2 children should get it or whether the 2 children and the 2 grandchildren should get it. It was ambiguous. The will was written in a way that's ambiguous. That's an issue. I've got to get that resolved before I can distribute the estate. What else? I have in one case a person who might be an heir and may not be an heir. A person died without a will. They died intestate. There were 3 children or 3 siblings. One sibling died. One sibling is alive. Actually, 2 siblings have died. And one sibling is alive. So that one sibling is certainly going to get part of the estate. The survivor of the children of one sibling who died, who we know that's that child, she's going to get what that sibling would have gotten had he lived. But then there's one sibling who died, and we don't know if this is a legitimate child or not. We have no idea if he was a child. So that's a problem. I've got to solve that problem. So those are issues about, who gets paid from the estate. You can have issues with regard to property that is that takes a while to get a hold of the property and run it through the estate. That can be an issue. You can have issues with claims of debtors that you think are not true or invalid or did something wrong. You might have an issue with that. You may have an estate that doesn't have enough money to pay all the creditors. That's called an insolvent estate. That's a whole other issue. So there can be many, many issues, problems that occur with estates. That's why there are attorneys that specialize in estate administration. All of that in Virginia has to be resolved with the Court of Virginia. Suppose there's property in another state. Suppose there's real estate in Delaware. They have a house in Delaware, in Rehoboth Beach. Does the Virginia court have jurisdiction over that property in Virginia in Delaware? It does not. That executor will have to open up a separate estate in Delaware to deal with that property, because Virginia can only deal with Virginia property. I'm talking about real estate. Now, you may have investment accounts all over the place, That's fine. The person died in Virginia, so that's where the residency is. So you can handle that. But if there's real estate in other states, Virginia doesn't have control over that. There is another strange thing about real estate in Virginia. There's another very strange thing. Real estate in Virginia, the executor doesn't automatically have control over real estate. So if I did a will and a person is dying and I left everything to her father and her brother, and the only probate asset is a house, the executor has no power over that house. What would happen in that case is that upon the person's death, we would probate the will. We would file the will before the circuit court in Arlington, because the property's in Arlington. File the death certificate, do all the notices and so forth, but we're not going to open up an estate. We're not going to sell the property. The executor is not going to sell the property. All they're going to do is put the will on file. Why is that? Because under the will, it says that the father and the brother own the property. And that's all. That's all that's needed. At that point, as soon as that person died, the brother and the father own the property. They own the property. And the executor doesn't have any power to do anything unless they want the executor to sell the property. Then the executor can go ahead and sell the property. But they have to get a special power of sale. Now, sometimes I put in my wills, I want my executor to sell any real estate, and I give them a power of sale to do that. At that point, the house does come under the authority of the executor. But unless it has that language, it does not. That's not true in other states. That's not true in DC. It's not true in Maryland, but it is true in Virginia. Virginia drops to the beneficiaries at death automatically. So that's a little quirk about Virginia and real estate. Virginia has a different view about real estate than other states, and that's kind of surprising. It took me a while to learn that, but that's what we do in Virginia. Property drops to the designated people under the will, or if there's no will, to the heirs at law automatically. That could be a good thing, it could be a bad thing, who knows? Okay, I'm going to stop for a moment and see if Elizabeth has any questions.
Yes, we have questions in the chat. First question, what proof is required to show that you are the executor?
Okay, so when you file the will, you're going to need to bring the will, not a copy of the will, the will. The will, if it's done correctly, has been signed by the decedent, and there is something else called a self-proving affidavit that's been notarized. And it says in the self-proving affidavit that we, the witnesses, saw this person sign the will on this day and at that point, and we were there in the presence of them both, and we saw her do that, and that's it. And it's the witnesses' statements are notarized, and the testator is notarized. If the will has that self-proving affidavit, then all that's needed is for you to bring some ID. And you say, our Ed Zetlin is the executor. I bring my driver's license. That's all you need. So that's it. You show up with some ID.
Okay, so This question, immediately after death, how does the executor pay for cremation burial costs of the deceased if they cannot use the deceased credit card or money in the deceased account, and the estate has not yet been opened nor executor received official appointment letter?
Okay. This is a good reason for everyone to do pre-planning. Okay. To pre-plan such expenses before you die, because that is a problem. Technically, the executor is not going to have assets to pay for the funeral expenses. Somebody else may have to front the money. Now, and in fact, under Virginia law, there are some limitations as to, well, certainly if there's no will, there's a limitation as to what to pay for. Generally, you can get, so somebody else, if it hasn't been pre-planned, has to front the money. And then when the executor opens the estate, they can get permission to reimburse the person who did the burial. But you're right, until they open up the estate, which is not going to be right away, it's not going to be the next day. First of all, you can't even get an appointment to file your probate appointment right away. And they're in Fairfax, it could take a couple of months. They got a lot of people in Fairfax. So don't think that happens all at once. So that is an issue. It's better to have that all prepaid. That's a good thing for you to do so that your executors. Now, if in fact your estate is passing through a will, that could be a problem. You want to prepay that. Next question.
Okay. Wouldn't it be easier to set up a trust rather than having to go through probate?
Yes, it is. So if you did a trust, and you put all the assets that would have to be probated in the trust before you died, then you don't have to open up an estate. You don't have to open up an estate at all. The trustee has full control to pay the debtors, pay the taxes, and make distributions. They don't have to file accountings before the Commissioner of Accounts. They don't have to file inventories. They don't have to do any of that stuff. So that's why we tell people they might want to think about doing a trust. Now, you may not have to do it because we know that all the assets are going by beneficiary designation. Okay. Other people just don't feel comfortable doing a trust while, doing a trust. For whatever reason, they don't like it. So we're not going to do one if you're not comfortable with it. But yes, the living trust, one of the reasons we do living trusts is to avoid all of that. That's a good point.
Okay. If the estate only has furniture, jewelry, art, knickknacks, and no money, then is there any need to open an estate?
No.
Or is it just necessary?
No, don't open it. No one opens an estate if all that's passing are, the furniture in the apartment. The Commissioner of Accounts doesn't want you to open up an estate for something like that.
Okay.
They don't want that.
As a named executor, what information is reasonable for me to ask for prior to the person's death to help facilitate my eventual job as executor?
Well, first of all, you should know where the original will is kept so that when time comes, you can get the original will. Okay? You should know what kind of future burial plans there are, if there are any. You should know, I would say, if there are, you might want to have some idea of what the person's assets are and how they're held. Because the first job you're going to have to do when the person dies is, do I need to open up an estate at all? So you, it would be a good idea to become aware of that if that's possible. So that's the immediate things I can think of.
Okay. In your experience, roughly what percentage of people open up an estate?
I have no idea. I don't know how to answer that question.
Okay. What is the easiest way to leave money for a funeral? Are all the bank accounts frozen? If a joint account, can other
And no
people
one, if
get
a person
money?
dies, the bank is not gonna, the bank is not gonna give you money until the person qualifies. Okay. So, because they know the person's dead, so you can't go to the bank and say, hey, I'm a beneficiary, or I paid the funeral. As I said, the best way of doing it is to pre-plan it. Every funeral home and you can always pre-plan, your burial, your cremation, whatever you want. That's what you do. And then there's really no expenses, except very minimal expenses. That's the best way of doing it.
Okay. If a house is in the deceased trust, can the house be sold by the successor trustee in Virginia so that the assets
Yes.
can be distributed?
Yes, unless it says my house is supposed to go to this person. So the house could be distributed directly to somebody, in which case the trustee is just going to prepare a deed and transfer the house to that person. Otherwise, the trustee is going to sell the house and distribute the proceeds. Every trust has kind of a will in it. Every trust has a will. It says where the property goes when the grantor has died. So they just the trustee has to follow the instructions about where the property goes upon the death. So that's what
Okay.
you probably have answered all the questions.
No, I'm scrolling.
Scrolling. Oh my goodness.
Okay.
All right. Well, let's
Now,
keep going.
how does the executor get the will if the original is filed with the court for safekeeping?
Well, you can go to the court at that point and get the will. Give them the name and they can get the will. That's not a problem. The problem is you can't find the original. The probate court is not going to accept a copy. You're going to have to go to court and get a judge to say, okay, we only have a copy. This is what's left. The presumption is this is what the person wanted. I'm going to approve that. So if you don't have the original, you got to get a court to approve it.
Okay. Would any of the special hearings protect against unexpected or unknown persons claiming to be illegitimate children who might show up later?
Yes, it does. It does protect it. It doesn't protect the people that got all the money. It just protects the executor or the administrator. That person could still have a claim against the other people that got the money and say, hey, I was a child of the decedent and I get a share. So they could bring a claim against the other people, but they can't bring a claim against the executor if you go through those proper procedures, unless there was something fraudulent.
Okay. Hold on, I just lost my place because someone else put one in the chat. Let's see. What are the downsides to having a trust, a living trust?
The downsides are that people have trouble understanding what a trust is, that you actually have to put assets into the trust. People are uncomfortable with doing that. They actually they deed their house into the trust. They take their brokerage accounts and put it in the trust. They get a new checking book that says Ed Zetlin as trustee of the Ed Zetlin Trust. All of that is very foreign and alien to some people, and they don't like it.
Okay. Can accounts with beneficiaries need to go through the probate?
The inventory is going to require to know what those accounts are, but they're not going to have to be, they're not going to have to, so they're not going to have to, they're not going to go through the accounting system. So yes, they're in the inventory. You have to list those accounts that are going to designated beneficiaries, but that's all that has to be done. They are officially not part of the probate estate. They're for information only to the Commissioner of Accounts.
Okay. Can you go to the circuit court or somewhere in Virginia to obtain a general written information and guidance on what to do when a person dies in Virginia regarding being an executor or a trustee?
All of the Commissioner of Accounts, Fairfax, Arlington, I don't know about others, they have websites. They have information about doing all of this. So you can check out their websites. Fairfax actually has, I think every month, a kind of, I've never seen it, but they do some kind of a call-in or course or something to people to answer questions. Now, they're not going to give legal advice, but they're going to tell people what the procedures are and what they require. So they can't give legal advice, but they can tell people what the procedures are.
Okay. The last question in our chat, are safe deposit boxes with joint names also frozen?
Yes, I don't like safe deposit boxes. They're a problem. They're a real problem. Well, if it's jointly and one dies, then the survivor has access to the joint account. The problem is what happens when the person dies. You know, the executor can get access to the safe deposit box. One of the problems I've had is I didn't have the keys to the safe deposit box. So we had to go through this whole procedure to have the safe deposit box drilled open, which was an expense. And when we opened up the box, there was nothing in it. So I'm not crazy about safe deposit box. You should never put your will in a safe deposit box in the bank. That's the worst place to put it, because you can't get into it until you're appointed the executor. And if the will is in the safe deposit box, how are you going to get the original of the will to get appointed as the executor? It's like a catch-22. The last place you want to put your will.
Okay, and our final question. In a family trust, there is a home that has a loan. What are the steps if there is a family trust?
Well, it depends on what the loan is and so forth, and who gets the property. But if the house is in a trust, family house is in a trust, and there's still a mortgage on it, you're going to have to, if the trustee wants to sell the house, a trustee can, sell the house just like anybody else sells a house with a mortgage. They sell the house, pay off the loan with the new buyer, get the proceeds, and so forth. That's what they do.
Okay.
So that's how it happens. Any more questions?
One more, and then we're going to wrap this up. Oh, thank you for the talk. It was very interesting.
Oh, very good.
Yeah, so thank you everyone for joining our 55 Plus program today. If you'd like Ed Zetlin's contact information, please email me and I will forward that to you. Thank you, Ed, for all this great information. Thank you for spending time with us. Have a great day, everybody. We'll see you next time.
Thank you. Excellent program. Thank you.
Thank you. Thank you very much.